It's a pleasure to introduce Andrew Schipper, who is Head of Africa Practice for Hogan Lovells. Thank you, Andrew.
Thanks, Liz, very much, and welcome to this this opening panel. This is the second of these events which I've attended, and this time around I think it's probably even more important post-Brexit. The conference, I think, aims to bring together leading lawyers from across the UK and Africa to help collaborate, network, and basically deliver customer satisfaction. This important panel, therefore, on the question of customer and client satisfaction is particularly important because I'm honoured to be joined by 4 General Counsel who I know well, representing a cross-sector of sectors, including global and multilateral players, each with their own valuable contribution to bring this discussion, and all of whom have worked in private practice, so they know what it's like on both sides of the fence, and you can't pull the wool over their eyes, as we say. This is a really important time, obviously, as the Africa Union seeks a new paradigm for Africa, as it puts it, and we are awaiting the opportunities promised by the Africa Continental Free Trade Agreement and increased collaboration, scale, and value add in and for Africa. This can only be effected, in my view, by a clear and certain basis for business underpinned by rule of law, and at the same time with SDGs and wider civil values coming to the fore, both societally and as part of a broader engagement and commitment by global business. The role of law, and lawyers in particular, and particularly lawyers in business, cannot be underestimated, and we're seeing more and more of that, and particularly, for example, the last week has brought that to a very clear focus for us all. So I'm especially to learn a bit more about this balance, given both my focus of the legal practice and also with my role as the co-chair with Emma Wade-Smith of the UK government's Africa Investors Group, which is designed to promote business and especially in the legal services side, where I am on the Nigeria-UK Economic Development Forum. I'm going to introduce you to my panel very briefly, and then I'm going to just ask them some questions. This should be great fun. My panel have enormous experience, and they are very eloquent on the matters which they care about most. So firstly, top left, I think we have Adesua Dozie, who's an executive director and the General Counsel of Mobil Producing Nigeria. Before that, she was the General Counsel of GE Africa, where I first met her, and co-chair of the GE Women's Network in Africa. Indeed, actually, I met Adesua at the first ever, I think, women-focused event at the Nigerian Bar Association, which was something to behold, I have to say, and very excellent. So there's Adesua. Then in the middle, from Afreximbank, you can see we have Samallie Kiyingi, who I think I first met with your work at the Tate Gallery, but we won't talk about that. General Counsel of African Export-Import Bank, who you will all know very well. She's Director and General Counsel of the bank, previously recognised as one of the most influential people of African descent under 40. And since I hit my 60th birthday this week, that seems like a very, very long time ago. So congratulations to Samallie. Chief Legal Advisor to Afreximbank, oversees the structuring, negotiation and documentation of the bank's transactions, covering various sectors, including trade finance, project finance, corporate finance and capital markets. So an enormous spread. And we've heard Dr. Arama on a regular basis telling us what Afrexim are trying to push through Africa. And it's critical, of course, that in the General Counsel's office, we have somebody who's pushing that as well. Like everybody else, Samallie has been in private practice and hold a number of senior positions in banks, including at Deutsche Bank. Michael Schottler, top right, who, if he showed his true colours, would be showing a nice beach behind him, I suspect, but instead you've got legal services are great. Is the head of the global disputes portfolio for Anglo American, who I don't need to describe. A large mining company, Anglo American, tells you what you need to know. It's based and it's South African based. Lead legal counsel responsible for all the disputes portfolio within that group. Michael is directly responsible for managing and executing significant litigation and arbitration matters affecting the group globally. Held that role since 2012. A long time in litigation. He might have finished one case during that time, maybe, speaking as a corporate lawyer, but that's probably going to get us sacked, so I won't say that. Michael's a good friend, as you probably just gathered. Nkateko Nyoka, finally, but certainly not least, who's Chief Officer, Regulatory and Stakeholder Relations at Vodacom Group, who are, as you will all know, doing enormous amounts of things across Africa as well as globally at the moment. Nkateko is Chief Officer, Regulatory Stakeholders Relations, and prior to joining Vodacom, he held several positions at MTN, including Group Executive for Corporate Services, where his responsibilities included legal, regulatory, company secretariat. He assures me that some time ago he was in private practice, but it was some time ago. And I'm very much looking forward to hearing from you all. So welcome all to my panel. I want to start really with a question to all of you. I mean, you all work for companies and organizations operating in Africa, but also as part of the global market. How do you see, this is a legal session, but how can you see lawyers helping deliver the Africa Union's new paradigm, which they're talking about, which we all have to be engaged with, which includes, for example, intra-Africa trade, value add in Africa, etc. And secondly, can you just give a characterization of the legal market in Africa from your point of view and your business, obviously acknowledging the fact that it's 54 countries, so one size doesn't fit all. I'm going to point the finger right at the center of the screen and start, I think, with Samallie on this as representing the multilateral focus on this. So maybe over to you, Samallie. Thank you.
Thank you very much, Andrew. And again, thank you for the invitation to join this panel. It's a very interesting question that you ask in terms of what lawyers can do, I guess, to help in this new paradigm. Because I think with the African Continental Free Trade Agreement, Africa really is at a strategic point of inflection. There is so much potential now that that agreement has effectively been ratified. But I think one thing I'd like to mention sort of upfront, and it is sort of a legal point, is that that agreement and that area needs to be seen in the context of the wider AU Agenda 2063 titled Building the Africa We Want. So the Africa Continental Free Trade Area is just the first deliverable, but it's part of this wider agenda, which was effectively sort of completed in sort of 2015. That's when it's been around by. And I think in terms of operationalizing Agenda 2063, and also the African Continental Free Trade Area, there are so many things that need to be done. The continent needs infrastructure, it needs financing, countries will need new laws, and lawyers have a huge part to play in that. And one thing I would say sort of very specifically in terms of what people can do now, to the extent that you haven't read the Continental Free Trade Area Agreement, or you haven't read Africa's Agenda 2063, encourage you to do that. They're long documents, but they really provide the blueprint for development in Africa over the next decades. And at Afreximbank, our 5-year strategic plan is very much aligned to what is in that Agenda 2063. So perhaps I will stop there. Or have I answered all your questions, Andrew?
No, there's plenty more time to answer all my deep questions, but that's a really good start. Adesua, do you have from the private sector side? How do you see the issues with that question?
Well, Andrew, thank you very much. First of all, good morning, everyone. It's certainly my pleasure and my privilege to join this panel, such a distinguished panel as well. So thank you for including me. It's a very, very interesting question. Africa, as we like to say, is not a country. It is fragmented and pluralized in a way. So from a client perspective, certainly what I'm looking for is contiguous service provision, which is challenging to provide where you have different laws, different rules regarding ability to practice law in different countries. You have protectionism, you have freedom restrictions in terms of freedom of movement. For illustration, in one of my prior roles, I remember being the Nigerian with a Nigerian passport who interestingly had more limitations with travel across the African continent than my European and American colleagues. They needed 1 or 2 passports. I probably needed 30 to 35 across Africa. So freedom of movement is certainly a challenge. And the question is, what can law firms do? What can legal service providers do to support businesses who require cross-border legal service? Partnership, scale. No law firm, a Nigerian law firm, no matter how big they are, can't provide me with the legal services I need for next door Cameroon, because there may be restrictions, legal restrictions for them to be able to practice law in Cameroon. So they would need to partner. If I needed an opinion, for example, with respect to, or I needed a service, the provision of a service with respect to Nigeria, Cameroon, and Benin Republic, the firm would have to partner because they're very different licenses / qualifications to practice law across all 3, despite the fact that, you know, we can practically touch each other. So what can lawyers do now to help us, Andrew? You can work together, partnership, collaboration, sharing. That's it for now. Thank you.
Yeah, that's fine. And we'll definitely come back to that. Michael, from your point of view, the new paradigm, whatever that means. But how do you see, in response to that question, how do you see lawyers operating in Africa in that context at the moment?
Yeah, cheers. Thanks, Andrew, and good morning, everyone, and good morning to my fellow panelists. I suppose what distinguishes my position slightly from my colleagues on this panel is we probably have a more limited exposure across the continent than a lot of my colleagues on the panel. Our operating areas are really focused on sub-Saharan Africa, but I think the principles and the sort of challenges that we face are really similar and identical, if you actually truth be told. So I mean, really, if one looks at what is the role of lawyers in assisting the new paradigm, the new vision, I think, you know, sort of, again, that's, you know, the concept lawyers, law, and the like, fairly interchangeable. But I think, you know, if one looks at what is that paradigm designed to serve, it's increased growth, it's increased trade, facilitated trade across borders and the like. And I think that's where the lawyers can contribute, external lawyers and the internal lawyers as well, and find creative mechanisms to improve those, but however, critically, without abandoning the sort of central tenets of the rule of law. I mean, in our industry, and I know for all my colleagues as well, we have an incredibly lengthy lifespan, you know, from inception through to design, development, and making a mine operational, and then post-closure. We are looking at many decades across our operations. So regulatory certainty, fiscal certainty, you know, again, you know, from a lawyer's perspective, and certainly from a miner's perspective, once we can categorize the risk and evaluate the risk and really quantify a risk, we can then evaluate whether the project is good, bad, or indifferent. Where our major risk element lies is changes midstream. So I think from the law perspective and from the lawyer's perspective, if we can ensure that there is regulatory certainty, things must change, but they must change in predictable ways, within confines, within structures, in a way that everyone can anticipate them, adapt to them. And you know, that is where your growth opportunity lies. And that's where you can then start developing cross-border and the like. So, you know, for me, the single biggest role of the lawyers is, you know, to ensure that there's that strict adherence to the rule of law, constitutional principles, common law principles, and the like, drive that regulatory fiscal certainty, and that, in my view, would achieve that growth that we're all seeking to promote.
Which is, and that's, I mean, it's a massive topic, obviously, and goes into the role of the public sector in the context of facilitating private sector to allow things to happen. And then I had a long chat with Jacko Marie yesterday, who takes who you know, Nkateko and Michael know, who has a very clear view on the private sector's role in South Africa at the moment, but it needs to be supported. I just wanted to add, when Michael has made clear to me earlier, I got stuck in my first traffic jam of the year today, as a result of which I forgot to make clear that all my panelists will be speaking on a personal basis and not speaking on behalf of their own companies. So you can blame the traffic, the first traffic in the last 12 months, for me forgetting to say that, but that's clear. So Nkateko, I think that's a broad range of points which have been raised already. How do you, I mean, and Vodacom are all over, pushing all over the place. I spoke to your CEO just a few weeks ago at the Africa Investments Conference. Very ambitious. How do you see you and lawyers embracing this? Because I think lawyers sometimes there's a tendency for lawyers to feel it's nothing to do with, we're just there to execute. And I think we've moved on. Maybe we've moved on from that. What do you think?
Yeah, so I think with the developments in the continent, I believe lawyers are uniquely positioned to play a significant role, both the social and economic development of the continent. And it manifests itself in different ways. As Michael pointed out, it's about regulatory certainty, which, by the way, it's very, very, very difficult to achieve in the continent. But I believe that other than the hardcore legal skills, lawyers by definition are very good facilitators. And that role can emanate from a commercial agreement that a lawyer is trying to put together, but you then come across certain obstacles. And our expectation is you need lawyers with broad knowledge such that when they pick up political issues, they are in a position to manage them, facilitate the dialogue, and eventually arrive at a solution that generally would represent a win-win between the parties who are sort of affected or involved in trying to find a solution to a particular problem. And the other reality over the years, trying to do deals across different jurisdictions, which, as has been admitted by one of my fellow panelists, can be complex in a continent of 54 countries. So I've always found it interesting that there is generally some degree of comfort if I do a deal in Nigeria, as an example, and we then choose the legal system that is going to regulate that arrangement as, say, English law or French law. But what that speaks to is essentially the transnational nature of the legal systems, which basically means some degree of collaboration can be required between lawyers who operate in South Africa, Nigeria, Cameroon, and the UK. And then if you have a one-stop type arrangement, what you then typically achieve is there can be one big firm, there can be multiple firms operating across the continent, but the skills are required to manage those dynamics and those relationships. Now, I think an equally important point to me is when there are disputes that comes out of any legal arrangement that we may have in any particular setting, lawyers do play a great role in terms of mediating that conflict, and to the extent necessary, maybe referring the issues to arbitration. So my point is collaboration is key. Lawyers as practitioners are typically respected by policymakers, and we do need to exploit that opportunity to facilitate deals between private companies, and to the extent that there are regulatory bottlenecks, use our skills to ensure that we facilitate dialogue with the policymakers and then arrive at solutions that basically take the economic progress of the continent forward. So those would be my opening remarks, and thank you.
I think there's a reasonable picture there. That sorry, we would say this, wouldn't we? But also, if you talk to most policymakers, most of them have been lawyers, I think, in their times across Africa. So it sort of helps. But I think the role of lawyers is. It seems to be the consensus that it's broad. It's broader than just execution, and whether it's collaboration or supporting trade and supporting regulation to facilitate trade. I think that's really important. I'd like to focus now, given the audience we have, who will be getting their notebooks out, I hope. I just want to ask you, in all this context, what do you expect external lawyers to bring to your business? I'm not talking about working with, not so much working, whether it's an international law firm, but what do you actually expect your lawyer to bring? Is it, just expertise? What sort of value add? Do you want them to have particular values? How does that work? Adesua, maybe start with you, and then perhaps move to Michael on that.
So thank you, Andrew. I think I want to say that there are a few things that are non-negotiable: competence, values, ethics, understanding that I have very low risk tolerance, right, for anything related to FCPA, UKPA, any perception of, I don't even want to say illegality, impropriety, right? So those are things that are non-negotiable and standard, right? So you want a competent lawyer who's dependable and can deliver. And you certainly would expect this from all your service providers. But going above and beyond means understanding that as a business, I'm not in the business of practicing law. I'm in the business of oil and gas or selling gas turbines. So if I have a problem, I really don't care about recondite issues of law, however interesting and fascinating they may be. They're nice to know and good for us to talk about, but I certainly don't want you to waste time making an academic challenge to the regulator. I'm looking for creative, practical, solution-driven counsel, right? Counsel who understands that I am not in the practice of law. So, I really don't want to make academic applications or be a test case. Now, there are matters of principles and my rights, which are non-negotiable. I will stand for my rights all the time against a client or the state, or, I really want you to protect my rights. But bigger is not better. More is often less. Creative is fantastic. And we really want commercial solutions that are easy to understand and easy to solve, not overly complex. I think lawyers, sometimes we get away with all the legal information and knowledge that we have, and we get carried away. So there are some things I think that are non-negotiable, as my co-panelist Michael spoke to, that are the basics, but to go above and beyond, and we certainly look for that in all of our legal counsel. Thank you.
Thank you. And it's this sort of commercial legal advisor, I guess. And Michael, I mean, you focus very clearly on the dispute resolution side, and same question to you really, and then maybe Nkateko after that, and then Samallie.
Yeah, sure. Thanks, Andrew. And again, I mean, just listening to Adesua, I mean, mirrors my experience exactly. And a lot of the frustrations that we have with law firms as well on occasion. And again, my primary focus.
You just tell us what really, give us a couple of what really annoys you points as well, because I think people would usually just write those down as well.
How much time
as long as it's not about me.
Happy to do that.
I mean, my personal all-time favorite is asking for a piece of advice on a very specific issue, getting a 40-page opinion with footnotes, quoting legislation, quoting case law from 50 years ago, with 4 footnotes later saying, but that one is no longer relevant because then there was a 20-year agreement sort of decision. Trying to find and distill what the actual conclusion is. Because again, sort of considering where we're at, we ask for opinions, we ask for guidance from external lawyers for a very particular purpose. And again, I'm exactly where the previous panelist was on this. I'm not in the business of soliciting law. I'm in the business of using legal principles to address a issue that I have. That may be a dispute, that may be a desire to resolve a commercial agreement. I need practical advice to get to that point. And again, it goes without saying, the lawyers that we appoint are, sorry, and who's that? Oh,
apologies. Is muted.
Apologies.
But she may have someone in the room with her.
Excellent. No, I mean, sort of the lawyers that we appoint, it doesn't differentiate them that they're really good in their field. That is the base premise of even getting into the door. That is not a distinguishing factor. Knowledge of the law. The distinguishing factors are, does the law firm, does it understand my business? Does it understand my commercial imperatives? Probably most importantly, does it understand my values of the company that I work for? Because our values are sacrosanct to us. And if a law firm is giving advice and doesn't understand my values, my commercial objectives, then they can't service my needs, because then they would be giving advice that is potentially at odds with those values, not aligned to sort of promoting those values and the like. So again, sort of everything that has been said is, sort of where does that law firm, how does it add value? And we're not talking about a 10% discount on standard hourly rates. That's not adding value. Adding value is understanding what my actual issue is, creatively working on a solution, being commercial in those solutions, rather than simply telling me what the law is. That really is what we are looking for in a law firm, and what differentiates law firms, those that can align their values and their approaches with my own values as the company, and work towards a common solution.
Yeah, it's very, I mean, I think all that resonates with my decades of experience in this space, particularly in terms of some of the companies I've worked with have very, very strict values, which would require you not to do certain things because of the risk level, which Adesua was talking about. The risk, the level of risk acceptable to certain companies is different, and you need to know that and understand it. I also think if you'll give it, sometimes some of my, not my colleagues, but sometimes legal colleagues of mine think that by producing a 40-page document, it proves they've done the work. I think, which I think is, it's never been, somebody wrote once, it's much, I think it was Winston Churchill, it's much more difficult to write a short memo than a long one. And I think that may be the message. So Nkateko, picking up that, I think there's some very good points there. And what, if you, both you and Samallie, maybe you could pick up the point about trust, I think, because I think where there's mutual trust, I mean, certainly as a as a provider, if I have a trusting relationship, I'm prepared to perhaps go the extra mile and be more more clear in my advice. I mean, what are your views?
Yeah, so I think the starting point is that the relationship between the service provider, in this instance an external law firm, and the company has got to be premised on an understanding that it's a partnership. We're working together on particular initiatives or projects to achieve a common goal, meaning there's got to be a process where each of the parties to that partnership arrangement exchange information. Of course, that speaks to a relationship of trust, and trust is typically earned. And it's earned, as has been suggested, as and when there is a specific problem to resolve. Don't present me with a 400-page opinion, because one, I'll never come.
Hopefully everybody's got the point.
And it's happened in my experience. There was one lawyer or law firm, they were trying to impress us. Telecommunications was a new field at that time. Then we had this 100-page opinion. Everyone in my team was battling to understand what's the number of the issue, what are you trying to address? And I typically argue that really a person who understands, or a lawyer who understands his subject matter very well, he would be able to condense information that would be contained in a 100-page opinion into 10 or 5 pages. And the value of that is that if it's 5 pages, it enables me as an executive or a director in the company to quickly make decisions. And the benefits of lawyers who are able to do that is that over time, they're going to earn my trust. And in so earning my trust, I typically trust their judgment. And it feeds into what the other panelists were saying, basically, that once you achieve that, you bring yourself to the fore of a partner who understands the business, who can assist us resolve commercial and business problems as opposed to legal problems. And my last point would be, experience is key to us. So I go to an external lawyer because they see different legal issues, different legal problems that pertain to veritable sectors. Now, I might have an issue that is communications specific, but if your point of departure is, well, in mining, in the energy sector, this problem played out, this is how it was resolved. I think that's much more valuable than presenting me with an academic an academic account that is drawn from various law reports, academic papers produced by academics. So in short, yeah, it's trust, you earn it over time. And then when we have that relationship of trust, I believe we'll build an enduring partnership. But significantly, is a demonstration that as a legal practitioner, you deal with different problems coming from different sectors, and you use that knowledge to assist me have a problem that I have.
That's a really, really interesting aspect, actually, that the dealing with the similar problems but in different sectors, because very often law firms are moving towards a sectoral approach in which a lot of people will have experience in the particular sector. So I think that's worth, but only in their sector, increasingly, which is a change in the law over the last few decades, which is considered to be by many a good thing. So I'm intrigued, so not for now, but I mean, maybe somebody picking up on some of those points. And do you, a lot of clients are now expecting law firms to be engaged in wider activities, whether it's pro bono or otherwise activities with them as partners. So picking up on the other points, but perhaps picking up on the relationship point and the trusted point, which Nkateko was just talking about, and moving that on a little bit to, you know, what does that mean in reality in terms of building the relationship from your point of view, because you've been on both sides.
Great, thank you, Andrew. And it's been quite interesting to listen to my fellow panelists because, yep, it's like tick, 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 all of those things apply. And just very quickly, sort of on legal opinions and things that we ask for. I mean, the truth is expertise is expected, but I don't mind a long legal opinion if it's necessary. Sometimes it is. But one thing I hate to say is that I don't want to have to decipher and interpret that opinion for my business. It should be written in such a way that I don't have to rewrite it in order to explain what's in there. That's certainly something I would say on that element. And the other thing I would say in terms of what I look for is really strategic thinking, and this sort of builds into relationship as well. Because it really starts from what my business expects from me. So they're my clients. So they don't expect me to just document things and provide them with advice. They expect me to strategize. They expect me to structure. They expect me to innovate. And so I expect that from my external counsel. And so an external counsel, if I give them an RFP, who comes back with not just a response, but saying, have you thought of this? And by the way, as similar to what Nkateko was saying, maybe in a different industry, this has been applied and it can apply to your situation, things that I might not be aware of. Somebody really thinking out of the box to try and help me drive and help my business forward. That's critical because anyone can follow instructions. But it's the law firms that take a step back and think, actually, what can I value add here? Given my knowledge of Afreximbank, given my knowledge of their ethos, their mandate, and all our documents are public, given what they do, is there anything else I can add that perhaps they haven't thought about? So that sort of innovative strategic thinking really sets a law firm apart in my perspective. And I think the other thing around building relationship is, you know, sometimes it's nice to hear from a law firm when it's outside of a transaction, there isn't a problem, and they're not chasing for their fees. You know, it's just nice, you know, it's just like Samallie.
Sorry, but you don't mind having those discussions?
I don't.
Sometimes we're shy about that sort of thing.
Absolutely not. Sometimes it's hard. It's hard to get a time in the diary, but these chats are 15, 20, 30 minutes. And some law firms are very good at doing that. And some people just call me out of the blue and, you know, if I can take the call, I'll take the call. But those things are appreciated because in those calls you can talk about maybe legal things that are happening in the market, the relationship generally, but it's not under a pressure cooker situation or perhaps something that's going wrong. And again, law firms that do that stand out because it becomes less transactional and more of a long-term partnership.
I think that's some really, really good insights, which I hope people have taken note of, and that's great from my point of view. I mean, I think really going back to Michael's point, one of the things which really strikes me is the need to, if you're working for a client, the first thing you do is probably look up their website, because on the front page they will have their values, and those values are things that they believe strongly in. If you look at the Johnson & Johnson, they have their credo. You look at Mars, they have their 5 principles, and they really believe in those. And if you come across and say something which clearly demonstrates you're not understanding that, you've got no chance with the General Counsel or the business people. I mean, I'm looking, just stepping back a bit. One of the biggest discussions, obviously, of the last few years, and will no doubt carry on, is And I think particularly in the context of the Africa Continental Free Trade Agreement, where everybody's looking for scale, everybody's looking for cross-border, and how you deal with that. The trends for using bigger international law firms, to use a, for want of a better word, but acknowledging very clearly that this is increasingly a blurred distinction given the number of big in Africa networks, and also some of the international law firms being present much more in Africa. But I think it's still a valid question, working alongside local law firms. What do you, when you're doing these big deals, what do you demand of your law firms in terms of working together, and perhaps capacity building, working together in a mutual way for that? Maybe Samallie, because I know that this is something very close to Afrexim's core value, frankly. So maybe starting with you, and then Nkateko, maybe.
Thank you, Andrew. No, very interesting question. And one thing I would say is, bigger is not necessarily better. My focus is always on quality. That really is the focus. And I think when somebody says big sort of international law firm, it's this idea that there's a seamless service across, different practice areas, so you can go and it's a one-stop shop. I have to admit, very few firms do that very well. Because often you have a good relationship with a particular team, that works very well. But if you need something outside of their ballpark, they might give you to their colleague, and because you're a much smaller client, they treat you as such. And so that's something that I think perhaps sort of bigger law firms can work on in terms of client management. I guess making sure that the relationship flows throughout the firm. And moving on from that, relationships between sort of international law firms and local law firms is very, very, very important for us. I mean, one thing I should say in terms of how we operate is that because we are an international financial institution, and because of our multilateral status, generally speaking, we always have 2 sets of lawyers on all of our transactions. We will have international counsel, which is an international law firm, and we will have local counsel. So that's always a given on our transactions. And generally speaking, that works very well. But one thing, and you mentioned capacity building, which is something at Afreximbank we're very passionate about, for our clients, for in-house counsel in governments, etc., in the jurisdictions in which we work. We get a lot of offers from firms to provide us at Afreximbank with training, and perhaps provide our clients with training as well. But I'm yet to see a joint pitch between a local law firm and an international law firm. And something like that, fairly simple, but I think things like that also speak to, I guess, understanding at least my business in terms of how we operate. Because as I mentioned, all of our transactions have 2 sets of counsel. And so I'm really keen actually to see more collaboration between local counsel and international counsel. In effect, them strategizing amongst themselves how they can potentially provide a better service to the bank.
That's really interesting, and it's because a lot of us do a lot of work with in partnership with local law firms, and developing that I think would be a very interesting model for people. So get your pens out, everybody, write it down. This is really interesting. And Nkateko, from your point of view, how does that sound?
Yeah, so from an SA environment, for the moment, in a moment I'll speak about DRC and Tanzania. So in South Africa, you have about 4 big top firms, typically in terms of their skills, maybe to a degree comparable to the type of legal skills that you get in Europe. And naturally, when you talk to them about the need to partner with international law firms, the answer is we have the same skills as those firms, and therefore we shouldn't get into that partnership arrangement. Of course, for a number of reasons, we sometimes insist that they must partner with international law firms, and the reasons vary from, I'm doing a transaction in Tanzania, I've got local partners in Tanzania who, in historical terms, have worked with European firms. Now you need to do what the customer wants. But whenever we've entered into those type of arrangement, I must admit, recent case in Tanzania, partnering a local firm with a French firm, got very good results, and they were working very well together. Eventually, we facilitated the relationship. But for me, what is key in those type of arrangements, with the abundance of skills and talent that the international firms have, you need to have an arrangement where skills are transferred from the bigger firms to the smaller firms. That, in my experience, doesn't necessarily entail that the role of your international law firms over time are going to be redundant. But what it does speak to is that over time you build a very enduring relationship between the firm, a commercial operation in our case, the various law firms that you retained to assist in a particular transaction. Now, if you're speaking to South Africa specifically, there are legislative requirements that speaks to empowerment of the historically disadvantaged groupings in South Africa, meaning Black people in South Africa. And I think we would typically insist you transfer skills, you empower the locals, largely because if we achieve that as a company, we earn certain points towards our BEE, Black Economic Empowerment credentials, and then achieve particular levels. So we'll do that formally, but for me, it's not so much that there's a legislative requirements. I do believe if there's a sharing of information across law firms, what it does over time is that the quality of advice, especially if we tend to use the same law firms, say in Tanzania or DRC, the quality of advice that we get as a business is very good. So yeah, I would say it's significant. It skills transfer is empowering people, lawyers who operate in the local markets, both in the firm and outside.
Yeah, no, it's interesting because I think it makes, well, if you're not prepared to do that, then you're probably in the wrong business anyway, because it's you need to make it, there's a mutuality and respect about it, but also there's an efficiency element about it. You can get the job done better if that happens, I think. I mean, Adesua, do you have a picking up on that? But we'll talk. I want to talk specifically about diversity later on, but maybe pick up the other points in that now.
So I agree with the comments made by Nkateko and Samallie. I think from a provision of service perspective, the reason why do we want this? It's really because of the quality of service that we get, right? And also we have a commitment to corporate social responsibility to developing the company. We have national content development objectives. So it's a business, capacity building and capacity enhancement is also a business requirement for us. It's good business, apart from the fact that we believe it and it's one of our core values. We believe in it and it's one of our core values. We also have a regulatory requirement from a national content development perspective to invest in initiatives that do this. So, we encourage service providers to work together to collaborate. And as Nkateko said, ultimately this results in a better quality of service delivery.
Yeah, and that's great. So from my point of view, it gets you good relationships and good friends across the continent. But that's
absolutely
that's which is a bonus. And Michael, if you could pick up those points and just comment on those, I'd then like to move on with you specifically with your because of your litigation hat on. So pick up very briefly on those points, which I think have been well covered. We're at an MOJ conference, so we need to talk a little bit about English law, probably, and English jurisdiction. What are your thoughts about the role of English law on the continent now, and the role and leading on from that, the role of jurisdiction? Where whether it's English law or other law. Because I know that there's an increasing tension between the desire to both use local law, but also in particular to use the arbitration centres, for example, of which there seems that there are a few in Nigeria, for example. So how do you, this is your job. How do you analyse that at the moment? The role of, because one of the key elements of what the UK government are looking at the moment is the importance of rule of law and the role that English law and jurisdiction can play in that. How does that play into your experience on the continent? And then I'm going to ask the same question to others, but I think if Michael could lead on that, because I think he's it's what he does.
Sure, thanks, Andrew. And again, I mean, as I've indicated, sort of our spread across the African continent is probably no longer as significant as it was a couple of decades ago. And we've now got a spread really globally, across South America, in the Far East, Australia, North America, and the like. So I think we're experiencing similar issues globally as are experienced on the continent more generally. And just looking
at the role, picking up Nkateko's point is very good, transferring your understanding from one sector or region to another. So that's great.
Absolutely. It's across sectors and it's across geographies. And sort of certainly from our perspective, English law has a very, very important component to how we adjudicate matters, how we draft agreements and the like. Yes, we have our headquarters stationed in the UK, but that's probably not the only dominant reason for that. Very often, certainly a lot of the jurisdictions that we operate in have a direct or indirect foundation in English law. Certainly, we've seen the developments in the English law on topics that particularly interest us. English law and the English courts are certainly, my experience, starting to be a lot more outward focused than they probably were several decades ago. You're increasingly finding English courts themselves looking for guidance in other jurisdictions, the Americas, Far East, and the like as well. And I think that's a useful development in the English law provisions, because it does mirror a lot of the learnings that we ourselves adopt. And again, sort of from pure disputes perspective, again, one size does not fit all. Sort of in terms of litigation as opposed to arbitration, really, it depends on, the kind of nature of the issues, the size of the agreements, the kind of risk factors that are at play, whether we would prefer arbitration in certain instances over others. And even then, what choice of law? The majority of the choices of law are actually home country based. So, for our operations in South Africa, 9 times out of 10, it would be South African law, South African seat and the like, and the same for Zimbabwe. Where we have a sizable presence, we'd certainly prefer the rule, the seat and the governing law to be that of the country in which we operate. Where we find we go outside is in one of two situations generally. So a South African, Anglo-American South Africa contracting with a Zimbabwean service provider, deadlock over choice of law, seat and the like. And we found in 90% of the cases, in those instances, we would default to English law with both entities generally being comfortable. I acknowledge that we're not as prevalent in the Francophone countries, where I think the challenge may be slightly different, but for ours, it's fairly easy. The other issues where we have differing issues on governing law, seats, and choice of fora is generally where we have these sort of mega umbrella agreements that span various jurisdictions and the like. And in those, we would then use the sort of more traditional, well, generally English law, because even for those, sort of entities operating out of Singapore and the like, English law is still a very, very well-known entity. It's a predictable system, and there are well-established rules that creates that predictability chain in there. And then we'd use those fora. But again, it would be very unusual for a contract, unless it's in the hundreds of millions of dollars, concluded between two South African companies to have anything other than governing law being South Africa, seat being South Africa. And
that's the point about certainty again, which you made right up front, is very, very good as well. Adesua, and because you've worked for a couple of, broadly speaking, American companies. So how does that work for you at the moment?
So at the moment, in my work for Mobil producing, a lot of my big contracts, or the contracts that I would care about, certainly. So there are two buckets. One would be concessions with the government, and in that instance, I mean, your choice is limited.
Yes.
So it would be Nigerian law, Nigerian seat, Nigerian Arbitration and Conciliation Act, right? But for vendors and other sizable concession agreements, for reasons of certainty, predictability, speed, English law is a good choice, given the difference in nationality, difference in background. I would say, though, that, as Michael said, one size does not fit all. As you know, Michael, Andrew, I've had the privilege to work for a few organizations during the span of my career. And what I will say is that choice of law is not something to be generalized. New York law may be great for a particular transaction, but could open you up to significant liability for another. So it's not always a one size fits all. It's a serious question, and a question that has to be considered based on a number of other factors: the nationality of the parties, the transaction in question, and the risks that you can foresee. You cannot foresee all risks, but it's certainly a significant question. I don't think the nationality of the organization or of its parents is necessarily significant. What I would say is that what we consider certainly is the transaction and what is the best choice of law / seat that is appropriate for the. Thank you.
No, thanks. And Nkateko does the same question, I think, really, on that.
Yeah.
And then Samallie, and Samallie, could just to be clear, we're getting a number of questions coming up, and apologies for not name checking people as they come up, but you'll see that quite a lot of these questions have already. I'm weaving them in as we go, so. I'm not going to be name checking people, but just I'm trying to get as many of those questions in as we can. And then one of those questions, Samallie, when Nkateko's spoken, is around the some of the issues in enforcing AFTCA, I think. So I'll ask you that as we're going. So Nkateko, back to the choice of law question.
Yeah, I would like to say I prefer a situation where we probably doesn't contemplate English law as a legal system of choice. But my experience and the realities that I have faced is that typically across the globe, once it comes to a choice and seat of law, especially for the type of transactions that we do, the preference tends to be English law for the reasons that both Dozie and Michael have advanced. And just to add to what they said, I'll just use two examples to illustrate the significance of being able to close the deal if you agree on the applicable legal system. So many years back, I was working for MTN. We're doing a deal in Saudi Arabia, and we're a group of lawyers from South Africa at the time, very inexperienced with respect to the global legal market. And we negotiate an agreement with our Saudi partners. Eventually, it comes to the question of which should be the legal system that should regulate this agreement. And we immediately say South African law, comparable, has its roots in English law. And the reaction that we got from our partners in Saudi Arabia was that, okay, our preference is Sharia law. And then we started criticizing Sharia law. It became evident that the negotiations that had taken approximately 3 months to conclude are going to collapse. And in the end, someone sort of suggested to us over the phone that you need to settle for English law because that's the norm, that's what everyone in the world understands.
A good old-fashioned compromise. Yeah. I can't tell you the number of contracts which ended up in Swiss law on that basis over my career, but that's probably for another time.
Yeah, and I think the most recent example is Tanzania. We had a dispute with one of our service providers, and typically in most countries in the continent, I think there is a recognition that in order to regulate certain arrangements, relationships, be it with private parties or between the public sector and the private sector, you need a certain set of rules that will bring about certainty. Our reality across a number of jurisdictions in the continent, the rule of law is relatively weak. And this often plays itself out with the delays before any decision is issued, or if a decision is issued timelessly, you may find in some instances that the major issues that underpins a particular dispute are not fully comprehended. So in this specific case, I think our partners in Tanzania who felt aggrieved by a certain decision that Vodacom had made to terminate the agreement, preferred that the matter must be heard in the UK. And indeed, the matter was heard in the UK. It took about 3.5 years to get a solution. At the point of the referral of the matter to the UK courts, I came under a lot of pressure from our ExCo that maybe there's merit in us settling the matter. Of course, we were convinced as a legal team that we have a fighting chance. Then the matter was heard in the UK and the judgment delivered about 3 weeks ago and in our favor. So we became heroes in the company, one, for agreeing to the UK. But the point is, for some reasons, if you're dealing with a dispute that affects parties that come from different countries, be it in the continent or internationally in general, there appears to be a preference that to the extent that you need to choose the legal system, the English legal system is probably the best for the reasons of certainty.
Well, I'm sure that will be great news for the organisers of this excellent conference, this great, excellent conference indeed. So thanks very much. Samallie, to you, and if you could just pick up one of the questions, which I think is actually perfect for the Afrexim, which is some of the impediments to implementing AFCA, because I know that you've got I know that Dr. Arama is very focused on reducing those impediments. So just very briefly, on the other points we just made about English law, but then perhaps a small amount on that. And then I want to move to the really important question of diversity. And so I'll ask, maybe Sam, I was going to ask Adesua, but maybe Samallie, you could pick up on that to start with, and then we'll ask Adesua to pick up on that and then move around the table. But I think the AFCA point is an interesting one, because I was on a call last week with the in some very senior people in the auto industry about how important AFCA is going to be, but it'll only work if the borders work, and if you have a disaggregated logistics system which requires you to buy your tires from one place and your others from other places. If your tires happen to be made in Chad at the moment, you might be a bit worried. So I think there's a number of areas of concern about that. But sorry, I think I've thrown 3 questions at you in one, Samallie. So, but you're
I'll do my best to answer them all. We'll start with English law, and I agree with what my panelists have said. And I would just say, for me in particular, English law is important, partly because of the sector of law I operate in, which is international financial law. And international financial law is actually quite a globalized commodity, just in terms of how international finance works. So if you had a big deal with various international banks, whether you're in Africa or Europe, generally speaking, the agreements will kind of look the same. The market has largely moved towards, as much as possible, trying to standardize certain documents. You see this in the loan market with the Loan Market Association. You see this in derivatives with ISDA. And so in the world of international finance, it's not that controversial, because essentially people have gravitated, I guess we're talking about English law in this context, because of things that people have mentioned around certainty in particular, and the fact that it's well known. And one other thing I would say around perhaps why this has evolved in the way that it has, is because the common law, I guess, has, in a way, a unique feature: flexibility together with certainty. So within English law, you have incredible freedom to contract. Sort of whatever you decide to contract, even if it's nonsense, generally speaking, the courts will say, okay, that's what the parties agreed, we'll respect that. There is an incredible freedom, and that allows innovation. And on the other side, you have the certainty because of the principles of precedent, etc., as well, which means that people know that, you know, if you do have to go to court, sort of there's that level of certainty that people can be comfortable with. And those 2 features aren't recent features, and I think it's important to mention that. This is something, as far as I can see, back from law school, you know, this is from the 17th century, where English courts were effectively trying to attract legal work from Europe into the UK, where they increased their flexibility and their certainty. So European traders would settle their disputes in England rather than in Europe. So it's got a long history, and over time, people have just gotten used to it. And so for that reason, I think it is very important. And from our perspective, as Afreximbank, we operate in 51 African countries, different legal systems. And what we try and do is have our agreements, the financing arrangements, at least governed in either sort of 2 systems of law, English law and French law. And I have to admit, the bulk of them are in English law. And again, I come to it from the perspective as my mandate, which is delivering development. That's what I want to do. So it's less about what law I use and more about what can the law do. My job is to manage legal risk. It's much easier to manage legal risk in terms of a system of law, which, as my fellow panelists have mentioned, is many parties are very familiar with, in the context of Africa, neutral, and also within the context of just the expertise, the literature, the jurisprudence around that, very well established. That gives me comfort. That gives my shareholders comfort. It gives the rating agencies comfort. So it really is about, trying to find the best mechanism to deliver what we deliver in the best means possible. And I think you asked a question around enforcement and issues.
I mean, we've got 5 minutes to go, and I really want to get to the question of diversity. But I think the question asked was about impediments to Africa Continental Free Trade Agreement, and I know that you are putting in a number of facilitating financial measures to deal with that. And I was speaking to your colleague Gaynmore about that in a number of ways in public forum, I hasten to add, about that recently. So, I'm very keen to get on to the question of diversity. Your view, where you see, increasingly a focus of everybody in society is diversity, and it's certainly in our profession. How important is that in your activities and your choices in terms of who you're looking to support? And I'd like to start with Samallie, and then Adesua, if you could pick up on that. And then in South Africa, it's that there are regulated issues around BE, which we talked about, but maybe we can pick up those. And I think that, and could you just mention if these are part of your outside counsel guidelines as well, because we've been asked a question around outside counsel guidelines, and I'm assuming you all have them, but if you have them, please say yes, and if you include diversity in them, please let us know. Thank you. And then we'll wrap up. So firstly, Samallie, thanks.
I'll be very quick. So diversity, hugely important, and I would sort of put it into two buckets. Sort of international council. So we're an African bank, and within the African Union, the diaspora is seen as effectively the 56th African state. We are, the representation of people of African descent in partnerships is woefully low. And that is something that has been observed and something that we would like to see change. So that is very, very important to us. And you were talking about guidelines. We're actually in the process of discussing those guidelines with the president of the bank. Because again, representation is very important, given the environment in which we work. And the other thing I'd say, because there are a lot of counsel from various local law firms across Africa, and the thing I would say about diversity there, and I think Adesua might mention this as well, is that I would love to see more women, again, at the partnership level. And again, this is something that we are strategizing internally to see how we can work with our external counsel to support their efforts, because we do know those efforts are there, but there's still a long way to go. Thank you.
That's fantastic. Thanks. Adesua?
So thank you, Andrew. The question of diversity is one that is very important to me personally and to all the organizations that I've worked for. And I think we have to be careful. It's quite nuanced how we define diversity, depending on where you are and what the context is. Generally, in some countries it means race, in some countries it means gender, but I would say across the African continent, diversity generally means gender and geopolitical. Certainly for Nigeria, diversity depends on where you come from as well. And I think, given the time left, I really just want to make the point that you can't talk about, representation does matter, but we can't talk about representation without talking about inclusion and equity and belonging. Yes. So I don't really want firms to have diversity for the sake of diversity. I'm looking for firms who can demonstrate that not only are they diverse, but they're giving people a seat at the table and an opportunity to include and belong. And the reason why is because ultimately there's a business impact. Diversity is not great for the same, for the point of diversity. As Nkateko said, he talked about diversity of law firms in terms of experience, right? So you value a firm that can say, listen, you're asking me this question from an oil and gas perspective, but let me help you understand what the challenge telecoms faced, and this is the way the regulator is going. So you might want to do 1, 2, 3, 4. And that's the reason why diversity is important, because it helps you to see breadth and depth and scale.
Yeah, or you just get an echo chamber, I think it's fair to say. Michael, very briefly, Michael and Nkateko.
Yeah, Andrew, thanks. I mean, this is a topic that we could speak on for hours.
It deserves a broader topic, but I want some really punchy.
Yeah, and I know that you've mentioned specifically, the Black economic empowerment provisions in South Africa, and obviously we comply with those. But our view, certainly as a legal department, is a lot broader. I think we've been pushing the diversity and keep pushing that across our jurisdictions. And it's, as everyone's indicated, it's not only race, it is gender, it is people with disability, it is ages, sort of making sure that we have the right mix in terms of age and experience and the like. To us, this is a founding principle in our engagement with our law firms. I mean, our key law firms, we actually measure according to standards, and diversity ranks higher than hourly rates. And again, it's not the number of persons of color on a particular team or the number of women on the team. It's active participation, it's meaningful participation. So we don't want to see the faces around the boardroom, but never hear them speak or never be the contact person. We are looking at actual billable hours, sort of per matter, proportion of the slice has to be significant. When the phone gets picked up and we get feedback, we want to hear from those alternative voices. We don't just want them to be the ones quietly sitting in the corner. So, to us, and again, sort of we've mentioned on the big law firms, our panel law firms, but on our tender processes, again, inclusion and diversity, absolutely paramount, because we see ourselves as, having a responsibility both as a company, but also being able to influence the industry. We've got significant buy-side power, and sort of we need to exert that for good, not coerce, not pressure, but we find that those law firms that we engage with that actually embrace diversity and see the benefit of it are more able to serve our needs than those law firms that see diversity simply as a tick box exercise, because those are not the law firms that are able to align themselves with our values and our direction. So again, could talk for hours, but let me.
But that's really powerful. And I think finally, and then I'll just wrap up, and Nkateko on the same point, I think those are 3 really powerful statements we've had. So to finish, the oratory of Nkateko can come to the fore.
I echo the sentiments of my fellow panelists, and I'm not gonna repeat what they've said, other than to say any law firm that seeks to be a partner and doesn't demonstrate that it embraces the values of diversity, it's highly likely that we would discard them from our panel.
Thank you. That's clear. Well, thank you to everybody very much. That was really enjoyable for me. We've covered an enormous amount with, as I would expect, some excellent, succinct comments. And I'm hoping people will have taken note, because these are the people who know what they're doing. They employ you, and I think we're picking up. The lawyers have a role way beyond just writing long notes. They've got to be engaged with the company. They've got to understand its values, and a critical value, and it's going to get more critical, is around diversity, sustainability, and engagement with society. So thank you to you all so much for that. And hoping that I'm not too over time, Liz, I'm going to hand back to you. So thank you very much to my panel. That was really excellent. Thank you.
Thank you so much. Really.
Bye-bye.
Really fascinating. I mean, we extended this session, didn't we, from the last time round? I think we need to extend it again because there's so much more to say. And you know, we've loved having you all. Thank you so much.
Okay, thank you very much indeed, and thanks, guys.
Thanks.
Bye-bye.
Thank you. Goodbye.